Superintendent, Assistant State Attorney. Both sides ready to proceed?
Yes, sir.
Okay. Okay, on Saturday, the defense filed a motion to determine competency to proceed. Based upon that motion, the court ordered that the defendant to be examined by 3 psychologists to determine her competency to proceed. The court appointed 3 independent experts. The first expert the court appointed was Dr. Daniel Tressler. Dr. Tressler examined Ms. Anthony on late Saturday morning, Saturday afternoon. The court also appointed Dr. Harry McLaren out of Quincy, Florida. Dr. McLaren examined Ms. Anthony on Saturday evening and some on Sunday. The court also appointed Dr. Ryan Hall, who examined Ms. Anthony on Sunday. Both sides willing to stipulate that the court may utilize the reports that were submitted by the doctors in making a determination on the issue of competency to proceed. What says the state of Florida?
The state will stipulate, Your Honor.
And the defense?
No objections on that.
Okay. Now, has both sides had an opportunity to review the reports of the 3 experts in this area?
State has.
Yes, the defense has.
Okay. Based upon the reports that the court has reviewed, the court will find that the defendant is competent to continue to proceed. Those reports will be filed, but pursuant to law, those reports will remain under seal. The originals now will be filed with the clerk of the court. Okay, are there any other matters we need to take up prior to resuming testimony in this case? I think y'all have cleared up any matters dealing with Dr. Further.
Yes, we have. Yes, sir. There is, for the record, there is no issue.
Okay, Mr. Ashton?
That's correct.
Okay, the court will file into the record the motion to determine competency to proceed and the court's emergency orders appointing experts. Let me see that one for just a second. Huh? No, not the report. I mean, the motion to determine competency under law can't be sealed. Not at this time. Just a second. Let me see that other. Okay, just a second. All right, Mr. Baez.
We're ready, Your Honor.
My name is Yuri Melish, Y-U-R-I-M-E-L-I-C-H.
You may proceed.
I please the court, Ms. Drain. Good morning, ladies and gentlemen. Good morning, Detective Melish.
Good morning, sir.
Sir, you were called on Friday afternoon to testify. and you misspoke, correct?
Yes, regarding some cell phone records.
Okay. Can you please clarify the issue that you misspoke about with the ladies and gentlemen of the jury?
In regards to cell phone records that I was questioned about on Friday, he asked me particularly about Roy Kronk. I was thinking of a different set of records when I answered that. As far as Roy Kronk is concerned, we did subpoena his records for June of 2008, June 1st to July 1st of 2008.
Now, the very first time that Mr. Kronk actually called law enforcement was until August 11th, 2008, was it?
In regards to this case, yes.
Okay. And there were several calls made in August 2008.
Objection, Your Honor. Response based on hearsay.
Sustain.
The time period in question for Mr. Kronk as to his involvement in this case begins in August and ends in December.
That's correct.
And he is the gentleman that found Caylee Marie Anthony's body.
Yes.
And you did not seek phone records for any of those time periods from August to December of 2008.
Correct.
And Mr. Kronk lives in a town called St. Cloud,
Yes.
which is a significant distance from the area where Caylee's remains were found.
That's correct.
And his work is off of Curry Ford,
Yes, in that area.
and that is a little bit of distance from the location where the remains are found.
A few miles, yes.
And the cell records, had you have gotten them from August to December of 2008, would have been able to give you movement locations of that cell phone.
Your Honor, I'm going to object. He's asking you to speculate as to the availability of the records and what they would show at this juncture.
Yes, they would give me movement of where the phone was.
And you would have been able to tell if August 14th, Mr. Kronk decided to go to that location, or if his cell phone was in that area,
What area are we referring to?
the area of Suburban Drive where Caylee's remains were found.
It would tell me the area the cell phone was in, but also keeping in mind that there is a highway, a north-south highway between, or in that general area as well. So yes, it would give me a general area.
It would give you a general idea if he was in the vicinity, within a certain 3-mile radius, correct?
Give or take, yes.
And you could also find out if in September of 2008, when he did not have the route that included the area of Suburban Drive, if he happened to be there then.
I don't recall off the top of my head which times he had the route. I know August was one time. I know December was another. And I don't recall in the middle when he did or did not have that route. I don't think I could answer that.
Are you aware that if he had it in November?
I know he had it sometime between August and December, but I can't recall now when he had it. I'm not doubting he did. I just don't recall.
Understood. So you know on one month he had that route, but the other months he did not.
Your Honor, I'm going to object based on hearsay.
It's based on his investigation, Judge.
Sustain.
These cell phone records could give you information as to whether he was in the vicinity at times where his work schedule did not require him to be.
The cell tower records, again, will tell me what area a particular cell phone is at when it's transmitting or receiving a phone call. So to answer your question, yes, it would.
Okay. Now, is this the first case that you've given mistaken information to the jury?
Your Honor, I'm going to object. It's irrelevant.
Sustain.
Are there any other incidents where you misspoke to this jury?
Same objection.
That I'm giving an opportunity to clarify any previous omissions or?
Overruled.
Not to my knowledge, no.
So as far as you know, the only time you misinformed this jury was Friday afternoon when we spoke of this topic.
You're suggesting that I intentionally misinformed the jury, and I did not. It was simply that you're asking me questions based on a 3-year investigation, a lot of cell phone records. I don't know what you're going to ask me. So in respect to Friday's testimony, yes, I did misspeak. And yes, I did give the wrong date range for the time I subpoenaed Roy Kronk's cell phone.
Sir, I'm not suggesting anything. I'm just asking you simply if there's any other information that you gave this jury that was false.
Not that I can recall. Is there something that you wanted to bring up?
Well, now that you bring it up, let's talk about Mr. Anthony's cell phone records.
Yes.
You mentioned that you testified that you had George Anthony's cell phone records for June and July, did you not?
I can't recall what I testified to. I remember that there was a question of cell phone records that we had subpoenaed, and I wasn't sure if it was the home phone or cell phone. After leaving on Friday, I was able to verify, yes, we did have George Anthony's cell phone records, and we subpoenaed them back in 2008.
For what month?
I believe it was for the month of June and July of 2008.
Do you have those with you, sir?
I do not.
Okay. Do those include cell tower locations?
No, they do not. It's a PDF form, not a spreadsheet, so they do not have cell tower information.
Okay. And would that information have been useful to you as to being able to determine Mr. George Anthony's movement or his cell phone movement?
Yes, if I had a reason to even believe that that would play a part in this case, which at the time I did not.
Okay. Since then, have you decided at any time to go back and subpoena Mr. Anthony's cell phone records?
No, I don't recall issuing any more subpoenas for Mr. Anthony.
Okay. Now, you've subpoenaed quite a bit of other people's cell phone in this case, have you not?
When you say me, yes, in the course of the investigation, several were subpoenaed.
Right. You're the guy, you're the coordinator of this investigation, kind of like the quarterback, right?
Yes, but to infer that I actually did the subpoenas, no. But during the course, several were subpoenaed, yes.
Right. And that would include Amy Huizinga,
Correct.
a friend of Casey's, Jesse Grund, an ex-boyfriend,
Yes,
Ricardo Morales, another ex-boyfriend of Casey's,
correct.
Tony Lazaro, another ex-boyfriend of Casey's,
Yes,
Chris Stutz, a friend of Casey's,
yes.
Diane Taylor. Who is she?
It was referring to a number that was coming off of Casey's phone. At the beginning, we were trying to identify who Zenaida Gonzalez was. So we subpoenaed several numbers from Casey's phone to try and identify who the people were. I believe that's one of the names that came back.
Okay, Stephanie Kostakis.
It sounds familiar.
That's a childhood friend of Casey's.
I don't know what the relationship is, but I do recall the name.
John Chatt, roommate of Ricardo Morales.
Again, I recall the name. I can't recall the relationship.
Okay. Ronald Westenberger.
I recall the name, yes.
Troy Brown, another friend of Casey's.
Yes,
Jen Apprentice and a shot girl at Fusions.
one and the same person, yes.
Yes. Okay. Jamie Relander, another friend of Casey's.
Again, yes.
Brittany Schreiber, another friend of Casey's.
Correct.
So you subpoenaed all of these phone records, and you were able to get all this information, but you never got the information or the cell phone records of the person who found the body?
I had no reason to pull his cell phone records for that time. There was nothing to suggest I needed that.
Would the reason be that he did not tell you that he had called 4 months earlier on December 11th?
I'm going to object. He's eliciting information based on hearsay.
Sustained.
You, of course, find nothing suspicious with the circumstances surrounding the earlier calls in this case, do you?
Objection calls for an opinion.
I'll withdraw the question, Judge. All right. You also testified that you never confiscated Mr. Kronk's computer.
Yes, I don't recall getting his computer.
Yet, do you recall doing a search warrant to get a computer belonging to a woman by the name of Joy Ray?
Yes, I do.
Overruled at this point.
You did.
Yes, I did.
And this is a woman who claimed to have taken photographs of the area off Suburban Drive.
Yes,
She also claimed to be a spy for George Bush.
that's correct.
She also had been Baker acted by your department, correct? Shortly after interviewing her, you Baker acted her?
I don't recall Baker acting her. I recall she was Baker acted a few times, but I don't believe any were from our agency. It may have been an adjoining agency.
Okay. You identified her clearly as someone having mental health issues.
I hesitate to give my,
Relevance, Your Honor.
Sustained.
You got her computer, but you didn't try to get Mr. Kronk's computer.
I did, but there was a specific reason as to why I chose to get her computer.
Okay. And you also got Ricardo Morales' computer.
Yes,
And that's how you found out he was selling photographs to the Globe.
I recall that, yes.
Now, on December 13th, 2008, 2 days after Caylee's remains were found, you received an email from a gentleman by the name of Joe Jordan, did you not?
I did receive an email from Mr. Jordan. I don't recall the date.
And this was giving you information as to the area, was he not?
Objection here, sir.
Sustained.
Do you recall when you decided to turn that email over to either the prosecution or the defense?
Objection.
Relevance.
Overruled at this point.
I don't recall.
Do you recall if it was a year and a half later?
May I see the email in question, sir?
Ms. Burdick.
Same objection to relevance as to turnover dates.
Overruled at this point.
May I see the email that we're talking about?
While that's being brought up, sir, was this email only turned over after the defense had found Mr. Jordan?
I'd like to see the email first.
Okay. Do you have any knowledge of whether that email was turned over only after the defense found Mr. Jordan?
Before answering any more on the email, I'd like to see the email, please.
Sure. While that's being retrieved, you got it? May I approach the witness, Your Honor?
You may.
Thank you.
If we could have the exhibit marked for the record.
I can have one printed and marked as an exhibit. Shouldn't be a problem.
Okay.
I'm just trying to speed it up. I can show them.
Give it an identification number, just for the record, Madam Clerk, and we'll print it up.
Yes, so the defense FA.
All right.
Pardon me a moment while I read it.
Sure.
Okay.
Does that refresh your recollection?
Yes, sir, I recall that.
Okay. And my question to you, sir, was, did you only turn this email over after the defense had found Mr. Jordan?
I don't recall when the email was turned over, sir.
Okay. And do you know, or can you recall as to whether it was in the normal course of discovery or a significant time period?
Objection. This
It's been asked and answered by the witness.
Sustained.
I'll withdraw the question, Judge. Now, sir, you conducted in December of 2000, after December 11th of 2008, you conducted 2 search warrants on the Anthony home, correct?
One on December 11th and then a subsequent one, yes.
Okay. And in the first search, you of course had some knowledge of what was found off of Suburban Drive. What items, correct?
That's correct.
And that would include any items having to do with a Winnie the Pooh blanket?
Yes, I believe that was included in that first search warrant, yes.
Okay. And then on December 20th, you exercised, let me stop there. As part of your regulations, you have to leave a copy of not only what you confiscate, but a copy of the search warrant at the residence, right?
Yes, a copy of what we took and a copy of the search warrant, not the affidavit.
And did you do that on December 11th?
Yes?
Okay. And then on the 20th, well, let me go back for a second. On that search warrant of December 11, 2011, it would have indicated that, of course, you were looking for any items having to do with Winnie the Pooh, correct? Any bedding material?
It should all be listed inside the body of the search warrant.
And then also, if you confiscated any from the home, it would have been there.
It should be, yes.
Okay. So on December 20th, when you went back, did you share anything having to do with your investigation with the Anthonys?
I don't recall what we spoke to the Anthonys about when we went and executed the search warrant.
Is it normal for a detective to share information that's not made public yet with people that you're at a home where you're exercising a search warrant?
In general, it's not abnormal to share information with victims of crimes that may not be public, especially in homicide. But I don't recall specifically sharing any information with them that, I don't think I understand your question. I don't recall the conversation in detail with the Anthonys on the day of the search warrant.
I'm not saying you did. I'm asking you if you did.
I don't recall.
The investigation was confidential at that point, was it not?
It was an ongoing investigation. To say it was confidential, everything subject to the public at one point, I don't understand your question, sir.
Did you disclose any items that you found off Suburban Drive with the Anthonys? Did you tell them, we found this, we found that, we found this?
I don't recall any specific conversation. Not to say that I didn't have a conversation. I don't recall the specifics of the conversation with the Anthonys regarding what we had found on scene.
Can you think of a scenario where you would have told the Anthonys things that you found at the scene?
Again, I don't recall the conversation, and I won't speculate on what I could have said if I don't remember saying anything.
Okay. And of course, you would have documented on your police report what transpired during that search warrant, correct?
It's very general what I document on the police report as far as conversations, unless it's directly pertinent to what I'm doing. Light conversation like hi or what time is it and stuff like that, I wouldn't necessarily put in a report unless it was pertinent.
Now, did you deploy a cadaver dog on the other two cars at the Anthony home?
No, I don't believe I did.
At any time through July 15th through today, have you ever deployed a cadaver dog on George Anthony's car?
No.
What about Cindy Anthony's car?
No.
Did the issue ever come up that Casey may have driven Cindy Anthony's car at one point?
I remember during the course of the investigation that did come up, yes.
And that came up from George Anthony?
Yes, I believe so.
And did you later find out that that was not true?
We weren't able to determine it occurred based on e-pass records, so yeah, we don't believe it happened in that time frame that he originally thought it may have.
You requested the e-pass records from Mr. George Anthony, did you not?
I remember getting them from e-pass. I don't recall if we actually made the request to him or if we just went through e-pass.
Okay. Did you not request them and him not turn them over to you?
Hearsay, Your Honor.
It's not, here's,
Sustained effect.
you had to actually go and subpoena them from e-pass yourself.
I recall getting the records from e-pass. It's the most reliable place to get the records anyway.
And the e-pass records indicated to you that,
Hearsay.
Sustained.
I'll withdraw that. Now, did you ever deploy a cadaver dog in the Anthony home?
I don't recall ever doing so, no.
You had two cadaver dogs out there July 17th, 2008, did you not?
I believe two were there. I don't know if they were both at the same day. I wasn't present during most of the search during that time frame at the Anthony home.
At any time, did you ever request that cadaver dogs go through the home to see if they picked up on any scent?
No.
May I approach the witness?
You may.
I'd like to show you Defense Exhibit EZ.
That was easy.
Would this make it easier for you to explain to the ladies and gentlemen of the jury the locations of both the Anthony home and where the remains were found?
I could use it to explain it to them, yes. I don't know what the abandoned house is on top, though.
I'm not going to ask you to talk about that.
Okay.
Okay. Now, does that appear to you to be a fair and accurate representation of both the Anthony residence and the location off of Suburban Drive where Caylee's remains were found?
Yes, I have no objection with the generalization. Obviously, GPS coordinates and all that would be accurate, but the general area is correct, yes.
Okay. Your Honor, I'd like to conditionally admit this, excluding the portion, of course, of the abandoned house, which I've been tying together with another witness.
Any objections?
If I may look at the photo to see
You may.
if,
Subject to our discussion, I have no objection.
Okay, it will be conditionally admitted as defense exhibit number,
Number 57.
May I ask the witness to stand out?
witness may stand down.
Can I get the laptop? Can everyone see that okay, or should I bring it closer? Okay. Detective Melich, can you circle the,
Just a little bit so the prosecution can see it. If you just take it back just a little bit, Mr. Baez. Thank you, sir.
Detective Melich, can you please circle the general area where Caylee's remains were found and initial that? Okay, and can you please circle the area of where the Anthony home is?
Initials?
Yes, please. Okay, that's fine, that's enough. If I can have just a moment, I'll see if I have any further questions. You may have your seat, sir. Now, Detective Melich, Casey Anthony was arrested on July 16, 2008, correct?
That's correct.
And she was out on bond for a short period during late August and all the way through October, correct?
I don't recall the dates she actually went in and out, but generally, I'll accept that.
About a month or so, a little over a month.
I won't dispute that at this time.
Okay. And she was subject to electronic monitoring during that time period, right?
Yes,
Okay. Basically house arrest?
yes, that's correct.
Okay. And there were, throughout that period of time, give or take 5 or 10 media trucks outside her home throughout the time?
I can't testify to how many were outside the house. I know that there were at several times, probably throughout the time.
Okay. And the only time she was permitted to go anywhere was, of course, to check in with the jail and her attorney's office, correct?
To the best of my recollection, yes.
And wherever she went, the media followed.
I can't attest to that, or I can't answer that.
Fair statement to make, though?
I wasn't there. I don't know if they followed her every time or not.
Okay. I have no further questions, Judge. Oh, if I can have one moment, please. And since the indictment of October 14, 2008, Casey's been in jail.
Yes.
No further questions.
Cross-examination?
Thank you, Your Honor. Good morning, Detective Melledge.
Good morning.
The email that was referenced as your having received on December 13th of 2008, at that point in time, it was 36 to 48 hours after the remains of Caylee Anthony were found, correct?
Yes.
The Orange County Sheriff's Office, suffice it to say, was extraordinarily busy with the recovery effort at that point in time, correct?
Yes, that is correct.
The Orange County Sheriff's Office had also been receiving hundreds, if not thousands, of emails or tips or other information, relevant or not, that you, as the lead investigator in conjunction with other people, had to wade through at that time, correct?
Yes, that is correct.
At any point in time, did you receive a report that the car of George Anthony smelled like there had been a dead body in it?
No.
At any point in time, did you receive a report that the car belonging to Cindy Anthony had the smell of a dead body in it?
No.
The phone records that you subpoenaed or had other investigators working with you subpoena from Amy Huizenga or Jesse Grund or Ricardo Morales, Tony Lazaro, all of those individuals, did they also focus on that time frame of June and July of 2008?
Yes.
Okay, this was the critical time frame when Caylee Anthony was last seen and then ultimately reported by her grandmother to be missing, correct?
Yes.
Miss Anthony, Casey Anthony's phone records were initially subpoenaed for that same time frame, correct? June 1st through July 15th, correct?
Yes.
In an effort to determine where she was during any specific date during the time period where Caylee Anthony was last seen and when she was finally reported missing by her grandmother.
Yes.
And in subpoenaing those records, initially your effort was based on the information given to you by Ms. Anthony regarding this babysitter, Zenaida Gonzalez, correct?
Yes, that's correct.
Okay, information that was subsequently determined to be false.
Regarding the babysitter, yes.
And in an effort to find this babysitter or any reference or contact or possible third-party connection, these individuals' records were subpoenaed as well as Ms. Anthony's, correct?
Yes.
And even doing all that, you were unable to locate not only Zenaida Gonzalez, but some of these other names that Ms. Anthony gave you as individuals who had some information about Caylee's whereabouts. Juliet Lewis, another Jeffrey Hopkins besides the one that we heard from in this case.
And to include Raquel Farrell, yes.
Okay. People who, according to Ms. Anthony, had some connection to this babysitter.
Yes.
That's all I wanted to clarify. Thank you.
Redirect as to those issues.
I know you told Ms. Drain Burdick that you were pretty busy and with the recovery off of Suburban Drive, but this individual claimed to have information as to that location, did he not? that email?
Object to hearsay.
Sustain.
This was asked by Ms. Strain-Burdick, Judge.
Object to hearsay.
Sustain.
This person had information for you.
Sustain. Same question, Mr. Bass.
This is not, Mr. Jordan was not a new person to you, correct? In fact, you had gotten information from him before?
I recall communication with Mr. Jordan. I believe most of it was through email. I don't know if there was any face-to-face at any point in time. I don't recall.
He was helping you out, giving you information, putting you in contact with people, was he not?
A lot of people were trying to help us out and trying to do things and trying to tell us how to do our job and trying to tell us where to look. So he was one of many people who was doing that.
But you actually took some of his information and used it, did you not?
I don't recall what specific information I took.
Do you recall him giving you blogs that were posted from Cindy Anthony's brother?
I recall somebody had mentioned Cindy Anthony's brother was on a blog. I don't recall who mentioned it. It may have been, it may not have been.
You don't recollect that he's the one that gave you the blogs?
No, I don't recall.
Okay. Do you recall that he's the one that helped put you in contact with Cindy Anthony's brother?
I don't recall that.
Do you recall Cindy Anthony's brother's the one that told you about all of this wedding, of what happened at his wedding?
Sustain.
Now, you heard Mr. Strain-Burdick said that you hadn't gotten any information about Cindy or George's car smelling, correct?
Correct.
Did you get any information as to whether they had trash in their trunk for 3 weeks?
No,
Neither car.
I never had any reason to ask, no.
Okay. Now, Detective Melich, you were present when Deputy Forgy, the canine handler, did the actual inspection of the car, were you not?
On July 16th or 17th? Yes, I was.
Okay. I'd like to show you Defense Exhibit EM. If I may approach the witness here.
You may.
Sir, please take a look at that drawing. Are you familiar with that drawing?
Yes, I am.
Okay. And is that a drawing that you drew at a previous hearing in this case?
That's correct.
Can you put the date into the record?
The date of the drawing is March 23rd, 2011.
Okay. And does that drawing depict a fair and accurate representation of what you testified to on that day?
Yes.
Okay. And there you were drawing what exactly? Can you tell the ladies and gentlemen of the jury what you're drawing?
Well, I can't recall the instructions at the time, but generally speaking, I guess it was what I recalled of the date. The Deputy Forgy was called out with his cadaver dog to inspect Ms. Anthony's car.
Correct. And what you drew there was the forensics bay garage
Yes.
and also Miss Anthony's car.
Yes.
And on that drawing, you, of course, just put one car that Deputy Forgy had inspected, correct?
Yes, after the fact, you asked me to put a second car in there, but for the purpose of Ms. Anthony's car, there was only one car drawn at the time.
Okay. And you also testified that when Deputy Forgy deployed his dog, it was only on Miss Anthony's car.
Sustain.
Was there only one car that he deployed his dog on that you recall?
Yes, that I could recall, yes.
Okay. Judge, at this time, I would move item EM into evidence.
What says the state?
I have no objection to the drawing.
To be received in evidence, it states numbered.
Number 58.
I have no further questions for Detective Melich.
Any recross? Okay, Detective, you may be excused, subject to recall.
Thank you, sir.
Michael Vincent, Vincent.
You may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning, sir.
May I approach the witness, Your Honor?
You may.
Mr. Vincent, I'd like you to look at Defense Exhibit EJ for a moment. Is that a drawing that you drew at an earlier hearing in this case?
Yes, sir.
And is that a drawing of the forensics bay garage and Miss Anthony's car?
Correct.
And did you, I'm sorry, did you testify that that there was only one car that was deployed by Deputy Forgy?
Yes.
At this time, Judge, I would move that item into evidence. I believe it's EM.
What says the state? No objection to the drawing. If you received an evidence, as defense exhibit number.
I have no further questions.
Cross-examination.
Thank you, sir.
May Detective Vincent be excused, or is he subject to recall? You may be excused, subject to recall, sir.
Thank you, Your Honor.
Who's the defense next witness?
Good morning. Geraldo Bloise, B-L-O-I-S-E.
Good morning, Mr. Bloise.
Good morning, Counselor.
Your Honor, may I approach the witness?
You may.
Mr. Bloise, I'd like to show you Defense Exhibit EL. Is that a drawing that you testified to at an earlier hearing in March of this case?
Yes.
Okay. And that's of this year, March of this year.
Yes.
And does it show a drawing of the forensics bay and Miss Anthony's car?
Correct.
And did you testify that there was only one car that the canine cadaver dog handler deployed his dog on?
Correct.
I have no further questions. Oh, actually, I take that back. Is that a fair and accurate representation of what you drew that day?
Yes.
Judge, at this time, I would move that item into evidence.
What says the state? No objection to the drawing. Be received in evidence as defense exhibit number.
I have no further questions for Mr. Bloise.
Cross-examination.
Investigator Bloise, is it fair to say that the focus of your investigation on that day in July was Ms. Anthony's white Pontiac Sunfire?
Correct.
And this is what you were paying attention to and documenting for the Orange County Sheriff?
Yes.
Thank you.
Mr. Bloise, as a crime scene investigator, your job is to focus on the details, are you not?
Yes.
In fact, down to the very minute details.
Yes.
No further questions.
May the witness be excused.
Yes, sir.
No question.
All right. Sir, you may be excused, subject to recall.
Thank you.
Okay, ladies and gentlemen of the jury, we're going to take a 15-minute recess at this time. Please remember all of my previous admonitions. Any additional instructions on behalf of the state or the defense? We'll be in recess for 15 minutes.
4G, J-A-S-O-N-R, F-O-R-G-E-Y.
Thank you, Your Honor. May I approach the witness?
You may.
Deputy Forgy, I'd like to show you a drawing labeled Defense Exhibit EK. You take a look at that, sir.
Stuck. Yes, sir.
Is that a drawing that you drew?
Yes, sir.
And that was in testimony in a prior hearing in this case on March 24th, 2011?
I believe that's the date. 3/24/2011.
And what that depicts is the forensics bay garage and Miss Anthony's vehicle and another vehicle?
Correct.
Okay.
It's a rough drawing, not to scale, like I said in the hearing.
And do you show, or did you testify that there were 2 cars in which you deployed your dog, Garrus?
Correct.
And did you testify that the other car is someone else's car? It's unknown to you whose car that was.
Correct.
And did you testify it was a blue car?
I said I believe it was a blue car.
Did
That
you get
was-
it? I'm sorry. Go ahead.
That was my quote. I believe it was a blue car.
Okay. Did you testify or do you know what the license plate number is or who that car belongs to?
Absolutely not.
It was just somebody's car that was there.
Correct.
And when you began deploying your dog, you started with that unknown car.
Correct.
And you knew that the white Pontiac Sunfire was Miss Anthony's car.
I knew it was a car in question. I didn't know whose car it was.
Okay. Is there anyone that can corroborate that a second car was there?
Sustained.
Were there any witnesses that saw you deploy your dog on this car?
Yes.
Overruled.
Okay. Who else saw you deploy your dog on these 2 cars?
My canine supervisor at the time, which was Mike Carden, was my corporal.
Who else?
I never say his name correctly. The forensic tech, Geraldo,
Loisy?
I believe so.
Okay. Who else?
I believe Mike Vinson was there also, but I'm not sure.
Who else?
That's all I recall.
And is this the first time you've ever mentioned, either in deposition, hearings, or in court, of your supervisor being present?
No, sir. I mentioned it in deposition. I mentioned it whenever you asked me.
Okay. And did he fill out a report?
No,
Okay.
it's not common practice.
So the individuals that you just mentioned are the ones who can corroborate that you actually deployed your dog on 2 cars as opposed to 1?
The ones that I recall that were there, yes, sir.
And the reason you do 2 cars is so that way the dog doesn't falsely alert because it wants to please you. That's one of the reasons why.
It could be. The reason you do it in training is for that, but this was a real search. And I did it. There was no real reason behind it.
There's no reason why you deployed your dog on this other car who you do not know who it belongs to.
I just wanted to make sure his mindset was correctly.
Okay.
That's it. Just started working him, running him around another vehicle, just make sure his mindset's settled in, calm, and go right to my car in question.
And it has nothing to do with your training, which tells you you should have multiple cars that way it would prevent handler bias.
Training is different than a real world scenario, because a real world scenario, you're not going to have the opportunity to have a second vehicle there. In training, of course, you can do that. I believe that's why I did it this time, because it happened to be there. In that lot, there's a lot of vehicles out there, but this is the only ones that we were questioning. But in that lot, I mean, there's trailers, there's cars, there's all kinds of stuff. But in the real world, you don't have the opportunity to set it up that way. It just happened to be there.
You could have had them drive this car to where the other cars were parked, right?
I had her move it outside the bay. Could I have done it? I don't know.
Orange County was in possession of this car,
Correct.
and you could have asked, just like you asked them to take it out of the garage, you could have asked them to put it near other cars.
But it was.
My question to you is, you could have asked them to put it near where all the other cars were at.
It's next to another vehicle when it came outside the bay. Could I have moved it to the front of the lot? I don't know. It's evidence, so I don't know. I've never run into that.
Could you have asked them to move the car to where there were several cars there?
It's possible.
Right, but you didn't.
No.
No further questions.
You may.
What's the letters on the back of that?
EK?
A?
K. Kilo.
EK into evidence?
Be receiving evidence as defense numbered. Cross-examination.
Deputy Forgy, regardless of whether or not there was 1, 2, or 200 cars, you still knew that the white Pontiac Sunfire was the car in question, correct?
Yes, ma'am.
That's all I wanted to ask her.
Okay. May the deputy be excused, subject to recall.
Yes, subject to recall.
Thank you, Deputy Forgy.
Thank you, sir.
College of Arts.